bit of a little bit of where I get to dabble in pretending I went to law school. Because so much of what we're talking about within the single course of conduct world is really legal. It's interpretation of statute. It's the judge, the prosecutor, the defense discussing things. But even though that doesn't necessarily involve us from a guidelines perspective, it does affect us when we try to Hernandize or not Hernandize or get told, oh, this is a single course of conduct, but we're imposing 4 sentences, so don't Hernandize. None of those things. That is the worst sentence in the whole world. So let's get you through this so that at least there's an understanding of what the court is trying to determine so that it can help you determine what your responsibility is in following the guidelines. So as we start every training, and I won't belabor this point very much at all, we know that we always use the guidelines in effect when the current offense occurred, and that data is used to find all the things related to the current offense, like severity level, modifiers, conditional release, things like that. But with respect to criminal history, after the 2019 changes and the Robinette decision that happened in mid 2021, we now have to go and use those 2019 changes regardless of the offense date. That is of most particular concern when you have an offense that occurred before July 31st of 2020. In those situations, you're going to need to use the 2019 manual to find the guidelines, and then you can switch to go back to using that single manual because we didn't update all the manuals with those changes. So those are available on our website, mn.gov/sentencing-guidelines. Under the guidelines header, you can select guidelines archive, and on that page, if we were to sort that oldest to newest, it would go back and start in 1980. So we no longer have to deal with that idea of, oh, well, my office doesn't keep copies of the guidelines.
Hey, so fucking go in anything.
No problem. So let's talk about single versus separate course of conduct. And again, I want to point this out that I'm not an attorney at all. But I will tell you that in discussing some of these same concepts in trainings with defense, prosecution, judges, etc., I haven't ever been corrected for what I've said. So whether or not that makes it right, I'm going with it. So single versus separate courses of conduct. Technically, there are 2 statutes which are going to be responsible for making that determination. Is it a single or is it a separate course of conduct? So the first statute, 609035, is crimes punishable under different provisions. So this means that if somebody has multiple offenses that they've committed against a single victim, the court really needs to look at them and determine which one of those is the lead offense, if you will. Which one of those is really the one that the rest of them are all incorporated under, not necessarily a lesser included. We're going to talk about that statute, which is very different from this statute. But this is the statute that basically says to the court, if you think this is a single course of conduct, sentence on one of the offenses. Once you impose more than one offense under this statute, you have separate courses of conduct, period. Now, there are some exceptions to this statute within the statute, and we're going to talk about that a little bit more when we get to Hernandizing, because That idea of double jeopardy is going to come up here, both in this statute and in 609.04, the next statute we're going to talk about. But what I think can trip some folks up is that exception to double jeopardy. There are exceptions to the double jeopardy rule, which basically just means that if you're prosecuted for an offense, you can't be prosecuted for any other offense that occurred during that crime if it's a single course of conduct. Just like if you're acquitted of that offense and there were no other charges, they're done. They can't bring that case back. And so there are exceptions within this 609.035 statute that I want to point out to you because I think this is one place where it can bump up against what the guidelines say with respect to single course of conduct, multiple sentences. So within this 609.035, there are exceptions. And those exceptions read exactly the same way that our burglary, our kidnapping, and our meth involving a child or vulnerable adult statutes read, that notwithstanding, or excuse me, without regard to 609.04, which is the statute dealing with lesser includeds, conviction of the burglary, conviction of the kidnapping, of that meth offense, they're not a bar to conviction for any other crime that occurred as a result of that burglary, of that kidnapping, of that meth offense. But that same identical language that's in the guidelines and in this statute is further on in this statute with respect to certain offenses. Firearm, arson, fleeing a peace officer at any level, although the motor vehicle one is the felony in Minnesota, and then CSC first through fourth degree with force or violence. This language has exactly the same language that sentencing guidelines uses to say you can't Hernandize. Conviction of this offense is not a bar to conviction for any other offense that occurs as a result of it. So the prosecution is not hampered by the idea that if they want to prosecute the person for being a felon in possession, they can't also prosecute them for the assault that they committed. Or if they're fleeing a peace officer in a motor vehicle, they can also charge them and get a sentence and conviction on a DWI if that happened. And so you can see that some of these things are just like really complicated and really outside of our scope of what we do here. But the idea is really understanding this idea of single course of conduct, multiple sentences only refers to burglary, kidnapping, and that special meth offense, meth involving a child or a vulnerable adult. But when we see these other offenses and we see that language that is the same one, we could potentially run into issues. So we are going to discuss what those mean when we get to the Hernandizing section. But for now, I just want you to be aware that 609.035 is the statute that's going to govern whether or not this is a single versus a separate course of conduct. This is what the court needs to ultimately decide. Versus a conviction of a lesser offense. So if you convict someone of burglary and you convict them of theft over $5,000 because they broke in and they stole something, the conviction for the theft is not a lesser included of the burglary. It's an offense that occurred as a result of the burglary. But when we have lesser included, that's probably a term you're pretty familiar with because we use that a lot when we're looking at these multiple count cases and we're trying to determine, okay, what rises to the top? Where are the lesser offenses that were also charged within this complaint? And we find this almost all the time in a trial. When it's going to jury, when it's going to the court for a trial, the idea is that if they charge them with everything, they're bound to get a conviction on something. So, for example, if they charge them with an assault first degree and an assault third degree, if they get found guilty of the assault third degree, they absolutely committed the assault third degree as well, because great bodily harm exceeds or implies that you've also substantially bodily harmed someone under our statute. And so the court would say, no, 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 we're going to sentence on the assault first degree. The assault third degree is a lesser included. We're not going to impose a sentence on that one, but we're going to convict. And that way, if we have a conviction, no sentence imposed, and they appeal the assault in the first degree, and that gets overturned, the assault in the third degree steps up. And you may remember the case of the woman in South St. Paul that was shot by the police officer. And he was found guilty of many charges, the highest one being murder in the third degree, which is a very difficult offense to convict on for the prosecution because it goes into the idea of depraved mind and things like that. So there are a lot of things wrapped up in that. But he was also found guilty of manslaughter and another offense I don't remember. But I will tell you, with respect to what's important here, he was convicted and sentenced on the murder in the third degree and only convicted, no sentence imposed on the manslaughter. So that when he appealed his murder in the third degree and it was overturned, they didn't lose the case. The manslaughter stepped up and now became the offense, and now that's what the sentence was imposed for. So it's the idea of not taking away, of only they want to give the jury more options to say, okay, did they really rise to the level of great bodily harm? Or was it just substantial? And if they only charged assault first degree and they got a not guilty, they're done. That's it. That case is dismissed. It's over. So the lesser included involves also if they attempt to commit the crime. So they're not really sure if they can prove that they completed it. So they charge with the completed and with the attempt. If they get the completed, the attempt is obvious. A completed offense and an attempted offense, same thing. And then there's some that are a little bit, they're interesting, but they kind of ride within that assault idea, where if you committed an assault first degree, they can definitely prove that you committed the assault third degree. But simple robbery and theft from person is the one that I wanted to use here. This kind of falls into a crime necessarily proved if crime charge were proved. And that seems to work with the assault, for example, but that's not the case because the assault fits within one single type of offense. Simple robbery and theft in person are where we see this a lot, especially here in the metro, where the idea is under the simple robbery statute, it says if you, quote, take personal property from the person, end quote, versus what the theft from person says, the property is taken from the person. So oftentimes if we see a simple robbery and a theft from person, and the theft from person is what gets sentenced, we can often go in and see that it originally either started as a simple robbery and was pled down, or those are two separate counts and they agreed to dismiss the simple robbery in favor of the theft from person. But ultimately, if they came back and found them guilty of both, they would only sentence on the simple robbery. But I want to leave that asterisk on there, or point out that asterisk rather, that you want to confirm all of these ideas with the prosecution, because they're probably going to be making the separate course of conduct argument if they believe it exists, versus the defense would be making the single course of conduct argument if they believe it exists, and the court makes the final determination. But that definitely does not make things easy for you, because what does this mean for the guidelines? It's an absolute daily struggle for all of us to work through this, because the assumption is that you'll take care of it because you've got the guidelines, you know what you're doing. And that's 100% true, but not necessarily in this situation. And I will tell you that even though this is up to the court struggles with this. And so it was almost like I was working on this training last Friday, and a judge called and said, I've got this sale of fentanyl first degree, possession of fentanyl first degree, possession of meth fifth degree, possession of coke fifth degree, and a felon in possession. What can I sentence on? When they ask that question, I have a lot of questions that I could ask back. Were they different drugs? Yeah. Were they a mix of sale and possession? Yeah. What about the firearm? Are they going to try to prove it was an element of the crime for the first degree or the fifth degree burglaries along with the felon in possession? I could have asked all those questions. But what I chose to do was step back a little bit and say, okay, this is the court's decision. You need to look at 609035 and 609004, in which 609004 definitely applied to the sale and the possession of the same drug. But did it apply to the different drugs? I don't know. I don't think so. But common sense doesn't always win the day here. So we have to be certain that we just say back to the court, have you determined this to be a single course of conduct and you're only going to sentence on one of them, or are they going to be separate courses of conduct? Because the decision there for you is, will you Hernandize? And that's really all these two statutes boil down to, is will they or won't they be Hernandized? What do you do in those situations? Well, I'm going to do a little plug here within, because I thought it fit really well within today's series. We have something to help with these situations where you get that multiple count complaint and it's built within a single complaint, and they're all the same offense date, and there's just a slew of things and a very long narrative within the PC statement, and you're like, what am I gonna do? And the prosecutor says to you, well, just do worksheets on everything, but don't Hernandize. No, you can't do worksheets on everything and not Hernandize, because 609035 says sentencing on more than one offense is basically a separate course of conduct. So what do? Well, you should start using the criminal history summary. This is, I like to call it the antidote for multiple count cases, stress headaches. This is the criminal history summary. You're looking at a picture of it here. This is a test case that we ran for our trainings. This is going to give the parties ultimately what they're looking for when they say, well, just do a worksheet for everything. Don't Hernandez, just tell me what the criminal history score is. Well, why not just tell them what the criminal history score is and let them apply that to however they're going to negotiate it out or anything else? The criminal history summary is going to provide the starting criminal history score. It's going to provide them with extra information within the criminal history, including the severity level and the disposition date, which do not show up on priors, excuse me, on the regular worksheet. There's tons of room for comments here. 5,000 characters that will carry over to the final worksheet. And then disclaimers, which are CYA for you, that explain to them, hey, if you end up sentencing on multiple offenses, you're going to need to Hernandize. If you sentence on the DWI or the assault or the enhanced offense rather than the non-enhanced offense, criminal history can change. And you can see those disclaimers down there. And it's so great because it's really just the process of taking the worksheet and moving backwards. You're starting with criminal history, and I promise you, it takes about a minute to change it into a worksheet. Once you know, all you have to do then is go back in and add the offense, and that will process and show the statement, and it will turn this. I like to think of this as Pinocchio. It will turn this into a real live worksheet that you can then present to them for what will actually be sentenced. So I can't stress enough how great this criminal history summary is. If you're not using it, try it. Just try it the next time you get a multi-count complaint and see how that goes. And with respect to using the criminal history, I want to show you something that happened last year. We like to say some side effects of using the CHS are fewer missing worksheets and unintended departures. The worksheet on the left that you can see for the burglary in the third degree, the agent completed the worksheet for the burglary third degree because that was count one. So sometimes they'll tell you, instead of saying, oh, just do them all and don't Hernandez, they'll say, oh, just do one for count one. So they did one for count one. And they imposed a sentence of a commit for 20, actually they imposed a sentence of a commit for 23 months, the lower end of the range. That's all well and good, except he was sentenced on a second degree drug offense, and his sentence should have been 98 months commit. I can't even begin to come up with any excuses for how that happened. I just want to say it's crazy that this would happen. So let's prevent situations like this. Let's make certain that we're getting the right worksheet with the right sentence for the right count in front of the judge. And I would really say that working within the criminal history summary is really the best way to do that. This is the anecdote for those Hernandizing headaches that are going to come up. But what do you do if that's already been decided? They've said, okay, we've decided, this is a single course of conduct with multiple sentences or a single course of conduct with multiple victims. So that gives you a lot more information on how to proceed. And this is where now we're going to introduce that idea of Hernandizing from the policy in 2B1E. The way 2B1, the first point in the felony section reads is that you include everything that received an imposed sentence or stay of imposition prior to sentencing on the current offense. So Hernandizing is actually the case that this came out of and ended up being the colloquial term that we now use with respect to this. But Hernandizing was a court case back in 1981. So less than a year after the guidelines were formed, the Hernandizing decision was made by the court that 2B1E was the policy. So it says that you include everything that received an imposed sentence or stay of imposition prior to sentencing on the current offense. All this case did was defined what before the current offense means. And it means if you have a sentence 1 and a sentence 2, then you're going to Hernandize. But as with all things guidelines, we do have 2 exceptions to this idea. The first exception is going to be what is called a single course of conduct, multiple sentences. Oftentimes, only that statement will get read, the title of the policy, and somebody will come back to you and say, well, you can't Hernandize here. It's a single course of conduct, multiple sentences. And how would you respond back to that? Well, you would say, actually, we can Hernandize because none of the offenses in this complaint is a burglary, a kidnapping, or the meth offense involving children or vulnerable adults. That's what single course of conduct, multiple sentences means. You have to keep reading the whole policy to say single course of conduct, multiple sentences involving a burglary, kidnapping, or that meth offense. Within the burglary and the kidnapping, they use the term double jeopardy within those 2 statutes. In the meth offense, it uses the conviction of this offense is not a bar to conviction for any other offense that occurs as a result. So what does that all mean for you? That means you can do multiple worksheets. You can do a worksheet for the burglary and a worksheet for the theft. You could do a worksheet for the manufacture of meth and a worksheet for the possession, or excuse me, the offense involving children or vulnerable adults. There's no prohibition here to sentencing multiple offenses. And so for that reason, the commission said, okay, let's not Hernandize these. Because as you saw under 609035, if this was a simple robbery and a theft from person, they'd only sentence on the theft from person, or excuse me, on the simple robbery. It would fit under this idea of single course of conduct, multiple sentences, except they wouldn't be imposing a sentence on the theft from person. But what if they said, we are going to impose a sentence on both the simple robbery and the theft from person? Don't Hernandize those worksheets, though. We want to see the same criminal history score on both of them. And that's where you would point them back to 609035 and 2B1E parent 1 and say, no, in this situation, because these offenses are not found in policy as to being an exception, you would sentence on both and Hernandize. But the burglary, the kidnapping, or the meth offense and the other offense, do multiple worksheets, but don't Hernandize. As an aside, when we are working with these in the future, we're going to only count the 1 at the highest severity level. So even though he receives a sentence on both the burglary and the theft, or maybe it's a kidnapping and a crim sex and it's eligible for consecutive sentencing and all of those things, pulling away from that and looking at these and saying, okay, this prior offense was a burglary and a theft, I can only count the burglary. I can only count the 1 at the highest severity level going forward. Within this 2B1E policy, single course of conduct, multiple sentences, and 609035 with Hernandizing. Back on slide 6, when we talked about the 609035 sentence, there are other offenses that carry that language of conviction of this offense is not a conviction or or punishment for any other offense that occurs as a result of the same conduct. So we talked about the felon in possession and the assault, the fleeing a peace officer in a motor vehicle, and the DWI. These were potentially single courses of conduct as decided by the court. However, these are not going to fit under that do not Hernandize policy. So here you would want to add section 2B109 to your comments, which says, yes, the commission recognizes that there are other offenses found in 609035 that say that same thing about conviction is not a bar to conviction for any other offense. The same thing as the idea that exists in section 2B1E, except we're going to stick to only the burglary, the kidnapping, and that meth offense, because there was a case back in 2009, State v. Williams, and it's a very convoluted case, and I didn't want to try to pick through it. So I just focus on the idea that this case exists. The attorneys can explore it if they want to. This case exists that said that he should not have been Hernandized on a felon in possession and the other offense that occurred. And the commission said, thank you, we've read through this. We're going to stick with only 609, with the offenses in 2B1E, parent 1. So anything else is going to get Hernandized. And they can explore State v. Williams. I'm sure that they can present it as a reason for not Hernandizing, but that would be a departure because the guidelines require you to Hernandize. And I know it's really tough when the court tells you, I want to see worksheets that are not Hernandizing. I'm ordering that. That's bumping up against the policies that are in the guidelines, which the court should follow, but can depart from. So whenever they're going to do this, they're going to have a departure, whenever they're going to not Hernandize a situation that is not found in section 2B1E, parent 1, it's going to be a departure. And we actually have a departure reason specifically for that the court can cite, is that they just felt Hernandizing in the situation was inappropriate. But the court's decision to do that is very different from what the policy says. And our responsibility as guideliners is to follow the policy. And if the commission wanted to take State v. Williams into effect, like they did State v. Robinette, like they did State v. Woodridge Carter with the stay of adjudication point, they would do that. They made a deliberate decision not to. So this 2B1E, parent 1, single course of conduct, multiple sentences, keep reading, involving kidnapping, a burglary, or that meth offense, and another offense that occurs as a result, no Hernandizing. We also, oh, I'm sorry, I forgot. These are the worksheets that you would present to the court that shows no Hernandizing. Okay, now single course of conduct, multiple victims. 2B1E, parent 2. A single course of conduct with multiple victims may potentially involve some offenses that would be categorized as lesser included under 60904. But again, leave that up to the court. Ultimately, here we could see a sentence for each victim. So if you had 3 victims, you'd have 3 worksheets. If you had 20 victims, you'd have 20 worksheets. The prohibition here is on the Hernandizing. It is absolutely not on how many offenses can be sentenced. I feel like that's my new thing. That's my new mantra is there's no prohibition to the number of offenses that can be sentenced in a multiple victim situation within the guidelines. The prohibition comes with the Hernandizing, and that says we're going to only Hernandize 2 at the highest severity level as we move through those cases. And there's a comment within 2B1 that I think it's 2B110 that talks about the decision for this was to avoid Hernandizing resting on the idea of prosecutorial manipulation. Like, you better plead guilty to these or we're going to throw the book at you and your criminal history score is going to be 100. No. The avoidance of that is to help the prosecution avoid that. They can get multiple sentences. They could get consecutive sentences. A lot can happen within these, except for the criminal history score increasing. So again, only 2 at the highest severity level are going to count as you move through the offense. As an aside, we have another policy like we did under 2B1E, 2B1D parent 1. We have 2B1D parent 2 here, which mirrors this and says in the future, you only take 2 from the entire course of conduct. So if you had 10 worksheets, when you get to the 10th worksheet, you only have 9 to look back at and pull the top 2 out of. But in the future, you would have all 10 to look back at, and you could take the top 2 from all 10. So that would look like this. So here we have 4 aggravated robberies. And you can see up through sentence number 3, it looks like normal, air quotes, normal Hernandizing. We've put sentence 1 onto 2 and 1 and 2 onto 3. But it is at sentence 4 that you actually see the policy in effect, and you actually can say it really takes effect because now you have multiple priors to choose from. And we take 2 at the highest, and we again only have the aggravated robbery. The single course of conduct multiple victims in a lot of cases is pretty straightforward once you can get into it and figure out what the order of events was and everything. I would say that criminal vehicular operation and homicide cases are very tough, especially when there are multiple levels of harm, substantial, great, and homicide within that same situation. So again, there's going to have to be an order that these are placed in by the court. This is another place that the criminal history summary can be helpful because there may be some discussion taking place with the defense and the prosecutor about the order and making the higher ones sentenced first so that they don't have, so although they have point impact on the lower severity levels, the sentences are less. There may be something going on with that. That's fine. If the court decides that was the order, that was the order. The criminal history summary will help you with that if it is not an absolutely clear order of events. So here we have the first aggravated worksheet, aggravated robbery worksheet. Second one, Hernandized. third one Hernandized, and then the fourth one that looks exactly the same as the third one. So oftentimes what I say is you may not necessarily have the same points on sentence number 4 that you had on sentence number 3, because maybe now you had a higher severity level that replaced one of the others that had been used, but you have the same number. So whatever they came in with plus 2, they'll have the same number of priors as you move through, even though the priors may change based on what's the now highest severity level being sentenced. So one final tip on Hernandizing is this. When it's a single course, when it's a single versus a separate course of conduct, one of the things that has to be done in that single course of conduct is they all have to be charged under the same complaint. So in those situations, you're going to be building the worksheet tree using ad-related offense, because you're going to just keep building within that court case number. So whenever you're using the ad-related offense link, you're going to have to ask the question, should I Hernandize these? To which the answer would always be yes, unless one of the exceptions applies. So how do we look at this? Do I Hernandize? We don't know what the issue is. We're just asking the question, do I Hernandize? If the answer is yes, that means the court has determined that they're separate courses of conduct and they will be imposing more than one sentence. Don't pay any attention to the fact that they have the same offense date. Don't pay any attention to the fact that they have a single case number. If they're sentencing on more than one offense and the exception does not apply, either exception does not apply, then you would Hernandize. Do I Hernandize? The answer might be no, because you have those multiple offenses that are being sentenced from the exceptions found in 2B1E. So you have a burglary and a theft offense. So here the answer to the Hernandizing question is no. I do not Hernandize here because one of the offenses is a burglary. The last question you would ask about Hernandizing would have a yes answer, because all of these counts are related to a single course of conduct, multiple victims. The court will be imposing multiple sentences, and you will be Hernandizing based on the policy in 2B1E parent 2 that says you can sentence on everything, but only include, well, let me be clear. The policy doesn't say you can sentence on everything. The policy says you can only Hernandize 2 at the highest severity level, which implies there will be multiple sentences. So Hernandizing, yes, we're all good. Separate courses of conduct. Hernandizing, no. Single course of conduct, multiple sentences rule applies. Hernandizing, yes, but single course of conduct, multiple victims policy applies. But when you use ad-related court case, you're gonna Hernandize. If you did sentence number 1 under one court case and then sentence number 2 under a different court case, there's no way those are a single course of conduct. If they were under 609-035, they would have to be charged in the same complaint. Now, does that mean anytime multiple offenses are charged in the same complaint, there's always an issue about Hernandizing? Not necessarily. It just depends on how the complaint was developed. But I can pretty much stake my reputation on the idea that if you're using ad-related court case and you're starting and entering a brand new court case number, then Hernandizing will apply. But if again you get pushback, point them in the direction of the policy and the statute and do your job under the policy, which says if you don't have one of those two exceptions, you're going to be Hernandizing. And again, I cannot tell you how much the criminal history summary will be a help to that. So that's it for Hernandizing. It also mentions Strobel. I wanted to save Strobel because we also have it coming up in a later training. Strobel is important, but it deserves its own time and its own conversation. Hernandizing, I felt, was enough. However, we have 10 minutes left, so I will turn my camera on and I can stand for any questions you have on anything. This presentation, Strobel, anything else that has come up. But before we do, I want to point out the disclaimer this time. It's the first time I've ever pointed it out. All information presented is not necessarily authoritative. We're fairly authoritative with the guidelines. We know what we're talking about, but always remember that we're not attorneys. We're just representing the guidelines policies, which you always want to try when possible to cite when you're having correspondence with the parties about the sentencing decisions.